and welcome to Estate Planning Essentials. My name is Maya Gordon. I'm a partner with Reynolds, Mirth, Richards & Farmer, who specializes in estates and estate planning. And we've put on this webinar to help people get an introduction to estate planning. Hopefully it's very user-friendly, but if you have any questions after you've watched it, please feel free to contact me or anyone on our estate team, and we'd be happy to help. Welcome, and we'll be going through a slideshow with lots of different estate tips and tricks and tools to help you through. So I hope that it's beneficial for all of you. So the first slide sort of works better around the Thanksgiving time of the year, but basically we thought we'd spice up this presentation with a few comics, and this one is from the New Yorker. And the turkey is saying, with Thanksgiving around the corner, I thought it'd be a good time to review my estate plan. So what I often tell people is it's really hard to find estate cartoons, but there's one for you just to start off. So when lawyers are talking about estate planning, there's lots of elements to that. There's a tax piece that's usually done with an accountant. There's often a financial planning piece that's done with your banker or your financial planner. And then when you come to the lawyer's part of estate planning, usually what we're thinking about is 3 documents. 2 of them occur during illness, so that's an enduring power of attorney and personal directive. Usually those come into effect when you're alive, but either unable or you've chosen not to delegate your powers. So anyway, the first 2 are when you're alive. The next document is after you've passed away, and it's a will. So those will be the 3 documents we'll focus on today: an enduring power of attorney, personal directive, and a will. And one of the reasons why we give this a webinar and why we do a lot of public education is that it's really important to think about why you are putting together an estate plan. It's usually not for you. So as we just saw, when those documents come into effect, usually you're not either mentally capable or physically capable to manage your own affairs, or you've passed away. So it's really helping the people who are left behind, and can be a real benefit if somebody needs to pay your mortgage, apply for disability insurance, make sure your utilities and taxes are paid, and it gives them the legal authority to do all of that. So the first section we're going to talk about, and these are really common and very useful documents, are the powers to assist with finances and the powers to assist with personal decisions. So we'll go through those first. This is another New Yorker cartoon. It says Night of the Living Will, and it has, I think those are lawyers coming towards somebody's house. Living will is a word that lots of people hear. It's not a word that we use in Alberta, and we'll be talking about it, but in Alberta, a living will is called a personal directive. It's just a term that we don't use that often anymore. So the first document we'll talk about is called an enduring power of attorney. This document appoints an attorney to deal with your financial affairs. Although the term attorney is used, it has nothing to do with lawyers. It doesn't have to be a lawyer that you appoint, but the person who you appoint becomes what's called an attorney. They basically step into your shoes for the purposes of financial affairs. So that means that they could, call the CRA to ask about what your taxes are, speak to your banker and make sure those taxes get paid, look at your utility bills, your mortgage, and things like that, and to ensure that that your bills are up to date. They can also, reinvest your investments. They can move your funds around, make sure that your long-term care is paid for. So they have a really significant amount of power, and so it's really important with these documents to name somebody who you trust. There are 2 types of powers of attorney usually when lawyers talk about it in estate planning. One is called a springing power of attorney. That's the most common. Maybe 90% of the ones that we do are springing powers of attorney, and they basically spring into action at a future point. So they don't come into effect the day you sign them. They have within the documents contingency that has to be met before the document comes into effect. So an example of a springing power of attorney would say, this power of attorney comes into effect when 2 doctors sign notes that declare me incapacitated. So that's a springing power of attorney. The other power of attorney is called an immediate power of attorney. Those documents come into effect the minute you sign them. They do them much less often, but if you were elderly and you felt as though, although you're mentally completely fine, but physically you're having trouble getting to the bank, you could create an immediate power of attorney, which doesn't depend on you losing your capacity to come into effect. Sometimes if people are going away on military service or a long trip, they could sign an immediate power of attorney as well. As I said, it really needs to be somebody that you trust, that you appoint, but they have a lot of power. One of the things they can do is support your spouse and your children. They also can sell land, which is really important and a very large power that goes to attorneys. The next document we'll talk about, this is a second of the 3 documents that we're going to go over today, is called a personal directive. This is the one that a lot of people know of as a living will. A personal directive appoints an agent to deal with healthcare and personal matters. So we just discussed an attorney. This person's called an agent. I think it's probably a better term because it doesn't sound like a lawyer. This takes effect on mental incapacity. So these ones can't be immediate. Obviously, medical practitioners want to take direction from you if you have the capacity to give that direction. But once you become mentally incapable, the personal directive can come into effect. Similar to the power of attorney, this document, you want to appoint somebody who can make the best personal decisions for you. They don't handle any money, but for example, they might choose where you live in a care facility. They may choose medical interventions that you would have wanted. They may choose a number of different things. So it's very important to name somebody who knows your personal values. They can decide where you live, what activities you take part in, and making medical decisions. A lot of personal directives, and this is usually the part that most people know of, talks about what happens if they're in a vegetative state and what medical interventions you would want in that case and whether you would want organ donation. So they are really helpful documents for a family. If you are in a vegetative state and the family doesn't know what to do, a personal directive can be very helpful. So the example that I often use to understand both documents is that if you had 2 children and one was an accountant and one was a nurse, you might name the accountant as your attorney and the nurse as your agent. It sort of involves different skill sets. Obviously, an agent is dealing in the healthcare system and an attorney is dealing with financial affairs. And so they're 2 different documents that we often include with an estate plan. So a lot of people ask me, well, I don't think I want to do an enduring power of attorney and personal directive. What happens if I lose capacity and I don't have them? And so the answer is that you then fall under what's called the Adult Guardianship and Trusteeship Act. What that act does basically is to create a guardian and a trustee for somebody in lieu of creating an agent and attorney. So if you think of it, if you're going to draft and sign the documents, the enduring power of attorney and personal directive, you're the one choosing, you're consulting with a lawyer, and you're choosing the person who you'd like in those documents. On the other hand, if you haven't done that, but you've now lost capacity, you can't make those decisions, you can't sign legal documents anymore, the court is going to have to appoint somebody to act in those roles. If the court is appointing somebody to act in those roles, the court really is going to need to be reassured that they're appointing the right person. And so there's a lot of background checks, there's credit checks, there's meetings with the public guardian, and so there's a lot of, I would say it's a lot more intrusive to do that. I once heard a lawyer refer to it as a difference between just having a child and adopting a child. People can have children and they can do that, you know, no matter what circumstances they're in. But if you're going to adopt children, you have to sort of jump through a bunch of hoops. It's very similar if you want to become a guardian and trustee. So I think the important thing to know is that it is possible to create basically personal powers and financial powers after you lack capacity, but it's much harder. It's also much more expensive. So if you're just drafting some documents that might be in the hundreds of dollars, to make an application to the court and do all of the paperwork related to guardianship and trusteeship might be in the thousands of dollars. And so when people are doing their wills, I often encourage them to do a power of attorney and personal directive alongside their will. And that way they've got the documents done and the family will never have to do adult guardianship and trusteeship. So another couple of downsides to guardianship and trusteeship, you have to account as the court directs. The accounting can be very expensive as well. You don't have control over the appointment. You can put forward somebody asking the court to appoint them, but the court ultimately is the final say, and the family is now in the court system. So an example that I often use is a client of mine. They had an elderly father. He did not do a power of attorney. He did not do a personal directive. And one of the children phoned me and said, we'd like to move him off the family farm and put him into a care facility. Then we'll need to sell the family farm. So how do we do that? And I asked her, well, does he have a power of attorney and personal directive? If he did, The agent under the personal directive could have decided which home he goes to, could have decided where he lives, who he's engaging with, and all of his medical decisions. And the attorney under the power of attorney could have decided when to sell the farm, how much to sell the farm for, and to put the money into his bank accounts to pay for his care. So I asked that, hoping that he had those documents, but he did not. Now, he was past the point of being able to sign legal documents. He was very advanced with dementia or Alzheimer's. And he, as a result, we had to go through the adult guardianship and trusteeship world. So the daughter put forward her application to be guardian and trustee. And as soon as it was filed at the courts, another daughter came out of the family and said she would instead like to be guardian and trustee. And she had a completely different plan, wanted to keep dad in the home, keep the farm running, not put him into care, not sell anything. And so it was two very different visions for how dad's care would go. And unfortunately, because dad had lost capacity, we couldn't ask him which of those visions he wanted. We also didn't know whether he would want to have stayed at home, whether he would want to be in care. And so it was really complicated. And although in this slideshow, we have some numbers for how much it would cost, in that case, because we had to go to court, it cost much, much more than $2,500. Also, it was just awful. There were two sisters putting in affidavits about how the other sister had mistreated dad, or that dad liked one sister more, and the family all kind of became very, very divided, and it was a very acrimonious file. So for some people who will never have the capacity to do a power of attorney and personal directive, so some people with developmental disabilities, you're stuck in guardianship and trusteeship and you just get those orders. But if you have the capacity, you have the time, I would always recommend getting these documents so that nobody in your family has to go through guardianship and trusteeship. So those are the first two documents we talk about, powers of attorney and personal directives. The last one we'll talk about is called wills. It's probably the document you were thinking about when we were talking about estate planning, and we'll go through some wills information and tips for you about drafting your own will. So another New Yorker cartoon, this one's from 1940, and it's an old gentleman saying, "Now read me the part again where I disinherit everybody," which may be the funnest part of drafting a will for some people. So the first thing we discuss is the importance of having a will. So probably because you've asked for the link to this webinar and because you're already this far in, you know that a will is important and you know that estate planning is important. You probably have relatives and friends where people have died without a will, and the disaster that has ensued. There can be a lot of family discord when somebody passes away without a will because nobody knows who's in charge. There can also be a lot of confusion about where somebody would want, you know, whether they want cremation or burial or where they want their estate to go. So those types of things, a will can really help. In my experience, if you have a will, it tends to be a significantly more smooth process for the family. There are two types of wills out there. One is called a formal will, one is called a holograph will. So the formal will is probably the one you're thinking of when you think of a will. It's drafted usually by a lawyer. It can also be drafted by anybody, but it's often typed, and it's signed at the end of it by two witnesses and then the testator. And testator is just a word for the person creating the will. The person whose estate is going to be divided. So it's signed by you, for example, and then two witnesses, and that's called a formal will. It doesn't have to be in your handwriting, it can be in somebody else's handwriting, can be typed, whatever. It does have to be in writing though, and it has to be signed. So that's called a formal will. Those are the ones you would do in lawyers' offices. That's what a will kit would be. Those are the most common type of wills. There's another type of will that's available in the prairie provinces, and it's called a holograph will. A holograph will is where you basically draft a document that's entirely in your own handwriting. So if I were to do one, it would have to be entirely in my own handwriting and signed at the bottom by me. Those wills don't need two witnesses to watch them be signed, and they just need to be entirely in the handwriting of the testator and signed by the testator at the end. Now, when I tell people about that, this is kind of weird because we're in a webinar setting, but in a more public setting, people's eyes often light up. They think, well, if I could just do it myself and write it all myself and sign it, I don't need witnesses, I don't need a lawyer, I don't need to spend any money. But the truth of the matter is holograph wills often have a lot of problems, and they're very commonly litigated. It's very common for courts to have to step in to help interpret what the person meant. The problem is you may think it's very clear when you set it out where you want things to go, but when you die, it may not be clear to other people what you meant by those words, or who you meant, or what you meant by live in the house for a period of time, or you know, sometimes we'll see holograph wills that talk about money or cash, and we're never sure whether that means investments, bank accounts. So there are a lot of interpretive issues with holograph wills. So often actually they end up costing the family more money on the back end from having to get the court to interpret and deal with them than on the front end for just getting them done. And again, you probably have seen this happen with family and friends, but wills can be challenged if there's proof of contrary intention. So it's just good to know that wills can be challenged, and we'll talk about some of the common challenges at the end of this slideshow. So the importance of having a will, I think this slide is very important, and you could screenshot it if you wanted to. It's a very important part of understanding how estate planning works. And it's usually the first thing that a lawyer will do when you meet with them is to talk about the assets that you own. And the reason why we want to go over that isn't because we're being nosy, but it's because we have to find out what assets you have in your own name, what assets you hold jointly with somebody else, and what assets pass through designated beneficiaries. The reason why that matters is because there's an increasing group of assets where it's going to flip to somebody else. And in the case of joint assets, that's usually the surviving owner. And with designated beneficiaries, it's the person designated as the beneficiary, as opposed to falling into your will and going the way you've directed in your will. So what passes under a will, that would include property that's specifically named in the will, property solely in the deceased's name. So for example, if I own a house just in my name alone, that will pass through my will. If I own bank accounts that are in my name alone, that's going to pass through my will. Anything that has no designated beneficiary. So if I have a life insurance policy, but I haven't bothered to name anybody, that would go into my estate and go under my will. What does not pass under a will, and this is sort of the more important point, is that joint assets, so things like property, and an example of that would be if two people own a property, let's say a married couple, and they own it in joint tenants. So it would say on title how you own it, but often couples own it at joint tenants. That means that when one person dies, the other person automatically becomes the sole owner of the property. It does not go in your will, and so it just flips to the surviving owner. And if you have joint bank accounts, they're very tricky, and actually there's a lot of court cases where people fought about joint bank accounts, so I would be very careful adding somebody to a joint bank account. But joint bank accounts between spouses, the assumption is that you would want that to go to your spouse, and that will often flip to your spouse. Joint bank accounts between adult children, there's a lot more complexity in terms of what the court will interpret you wanted to do with that account. But in many cases, joint assets flip to the survivor. The other thing that flips to somebody without having to even touch the will are assets with designated beneficiaries. So very common would be life insurance. Often when you sign up for life insurance, you have to write who the beneficiary is on the life insurance. When you set up an RSP, a TFSA, or a pension at your employment, often those will also include designated beneficiaries. And so that's an opportunity for you to just allow the asset to flip over to whomever you've named. And one of the things I always tell people when we're doing this presentation to the public is stop, well, because it's a webinar, you can stop this right now, but take the time to get out a piece of paper and a pen and write down the assets that you have and put a question mark next to each one where you're not sure. Are you not sure who you co-own the property with? Are you not sure who's on your joint bank accounts? Maybe you set up the pension when you started working at your company and you don't remember who is the designated beneficiary. Going through that analysis and finding out what things are joint, what things have designated beneficiaries, and what things are solely held by you and go through your will is usually a very helpful enterprise, because it allows you to understand what you can give away in your will and what's already been designated to go away. And often when we do that as lawyers, we'll find out that, for example, somebody's ex-spouse is listed as a designated beneficiary on a life insurance, which you do not want. Or you've got, you know, a minor child listed on an RSP, which you also don't want. And so it's a really good exercise, and often it involves calling your banker and asking them who you have as joint accounts, and you know, often a little bit of pulling title to make sure that your property is joint with your spouse and things like that. So I think one recommendation from this webinar that I hope you take away is that it's worthwhile, and doesn't matter the format, but I have it myself as an Excel spreadsheet of all the assets you own, what's in your name, what's in joint names with your spouse or your child, and what has a designated beneficiary, and just put all of that together. It helps you to organize it. It makes sure that you're double checking that accounts are going to go the way you want them to go. And it also really helps your executor. If you are handing over an estate to an executor, they really should know all the assets that you have so they can make sure to wind everything up It can be very hard to be an executor, and that may be a future webinar that we do about executor tips. But one thing that makes it a lot easier is if they have a listing of all the property that the deceased owned. And so I think it's just a good exercise to go. And often we have surprises in those meetings where people realize they have the wrong person named as their beneficiary. So it's a very good idea to go through that, even though it's a bit annoying, and I understand that. This is just to let you know, depending on how much you like reading legislation, that we have 2 pieces of legislation that govern us in estate law. I think of them still as new legislation, although I'm reading the dates and I'm realizing it's actually been quite a while. We updated and consolidated the wills legislation into the Wills and Succession Act. It came into force on February 1st, 2012. That act basically consolidated a number of old pieces of legislation into one act, and is supposed to be pretty user-friendly to read. So if you do want to find out what would make a valid will, what are void gifts, what would happen if I don't have a will, which we'll talk about later in the slideshow, that's all contained in the Wills and Succession Act. The other act is called the Estate Administration Act. That is for when after somebody's passed away, what are the requirements of executors? What are they required to do? What are the penalties if you don't do things right? And so if you ever wanted to know the answer to a question in either of those, the Wills and Succession Act and the Estate Administration Act can help a lot. There were some changes that were done. These were all done, in the past 5 to 8 years, but basically that marriage and divorce have changed. There was a section on matrimonial property that was never brought into force. There's a discussion of family maintenance and support, which used to be called dependence relief. What happens in an intestacy? Intestacy is just a word for when the person dies without a will. So it's called an intestate estate or an intestacy. And survivorship, so how long people have to survive you before they can get a gift in your estate. So those are some of the things that are contained in those acts. I don't think we can call them the new acts anymore, but if you want to Google them or are ever interested, those are the 2 to look up. So what are the basic components of a will? And these are things that every lawyer will include in a will. So if you're going to a lawyer, you don't need to worry. But if you aren't going to a lawyer, you need to make sure that the will contains these clauses. You should always make sure that you appoint an executor. We call them an executor trustee, and often through wills, you'll see an executor being called a trustee. They're a trustee of the estate funds, and so that's why we use that term. Also, wills can appoint a guardian for children under 18 years of age. That can be really helpful for families where, somebody has passed away and left a minor child, then you have an automatic guardian that's created by the will. Wills can create trusts. So you could create a trust for your minor kids. And basically all a trust is you designate a beneficiary, that could be your minor child. You designate an amount or a property, and that's in the trust. So the amount, whatever falls into the trust, and then you designate a trustee. And so the trustee is a person who manages the trust for the children or the grandchildren. And then usually they wind up at a certain age. So you could say when my children turn 21 or when they turn 25, you can give over the trust fund to them, because you don't want trusts to run forever. So you can create all of those trusts if you want to. Wills often dispose of family heirlooms and personal assets. And then usually what you need to make sure is that you're giving away the estate. So that's called a disposition. You can make specific dispositions. So an example of that would be, I'm giving the piano to Sally. You could make a disposition of funds. So I'm giving $50,000 to the Alberta Cancer Foundation, or you can make what's called a residuary disposition. And that sounds very complicated, but all that it means is that you say the residue of my estate goes to X, and you always need to make sure that you have a residue clause, because there are often assets that when you're thinking about your will, you haven't thought about, you haven't contemplated. So even if I were to make a list of all my assets, it might be that I get a pension payout, when I die, and I haven't thought about it. And if I don't have a residue clause, that's not going to be caught. So many wills, for a very simple example, say something like, I hereby give the residue of my estate to my spouse if he survives me by 30 days. In the event my spouse dies before me or dies within 30 days, I divide the residue equally among my children. That's how estate lawyers typically do estates, because we don't know what the changing nature of your assets are over time. And so we very commonly use the concept of residue just to say whatever I have when I die, that's what's going to form part of the residue. It's usually a net amount, obviously. You have to pay all of your debts and creditors off before you create the residue, but that's what's left. And the last thing that lots of wills contain is funeral instructions. That's fine to contain in your will. Lots of wills do contain it, but something that we often tell people is that you should tell your family what your funeral wishes are along with having it in your will, because sometimes wills aren't found until much after the funeral has already happened. So you want to make sure they all know what your wishes are. So giving in a will, there's different types of giving that you can do in a will. Usually wills give to family members. Sometimes wills give to charities that somebody would like to support. Some are specific amount of money. We talked about that. That would look like $100 or $50,000. Some are specific items in the estate. So that would be like a piano, a necklace, wedding rings, or pieces of property. So that would be, you know, my house in Edmonton, my cabin on Pigeon Lake. And some are a share of the residue of the estate. So that's very common. And like I said, you really want to make sure you're giving the residue to somebody at the end of the day. Any gift that you're giving, and this is what a lawyer will go through with you, you should always make sure that you have somebody behind that person to ensure that if the beneficiary dies, the gift goes over to somebody else. For a specific item that you're giving in a will, we would always recommend being as specific as possible. We're lawyers, so we've kind of seen the worst case scenarios. But I have seen wills that say, give the ring to my daughter, and the whole family has not known what the ring means. And if the rings are very valuable, it can really cause a fight as to which ring was meant. So instead of saying the necklace, you would say the necklace with the pearls on it that was given to me by my grandmother that's kept in, you know, this box or whatever, but you really want to be specific so that there's no confusion. You might think it's crystal clear what you're referring to, but the more information is better. If you have assets like a family cottage, you could also consider a trust to hold those so they stay in the family for a long time. But I would recommend consulting with a lawyer if you're going to do that. Charitable giving. So sometimes in wills, it's a good opportunity for you to leave funds to something that you care about. So I've had clients leave funds to the SPCA. I've had clients leave funds to youth emergency shelters. You know, something that's important to you. You get a tax receipt toward your estate if you do give in your estate. So it can also help offset some taxes that are payable when you die. But make sure that you find out from the charity before you include them how to, you know, include them. Each charity has its own specific name, and sometimes it's not the name you think it's going to be, so they can give you information about that. And again, there might be tax benefits to leaving a gift to a charity. So this always is very interesting to people because they think it's sort of silly, and maybe this will change in the future, but there's currently no registry or mandated location on where to keep your will. You should always keep it in a really secure location. My preference is always to have it in our lawyer's vault because that way it's safe, it's secure, and you know where it is. Some people put them in safety deposit boxes at a bank or in a fireproof safe at their house. The difficulty with both safety deposit boxes and safes are usually you're the one who knows how to get in, you know where the safety deposit box key is, or you know what the combination is for the safe. But you've died and now your family has no idea how to get into the safety deposit box or the safe. So for my preference, I always say a lawyer's vault is easiest. We usually operate based on a death certificate and ID to release a will, whereas drilling into a safety deposit box or a safe can be much more challenging. So if you are going to keep it there, make sure you give very specific instructions to your executor on how to get in to get it. And tell your executor where your will is kept. We've had lots of executors have to locate a will, which is really uncomfortable for them before they can even plan the funeral so they can show their authority. So make sure your executor knows. The last document, I know I said we were going to talk about 3 documents today, and we have the power of attorney, the personal directive, and the will. This is the last document. It's sort of a mini will. So I guess we're talking about 4 documents, but it's a very short note to say, if you ever heard of the term codicil, it's a legal document, which is basically an amendment to a will. It's signed with the same formalities as a will. So when wills were typewritten, it would have been very annoying to retypewrite, you know, 5-7 pages of text just to make one change. And so they would create a codicil, which basically said, I hereby remove this clause and add this clause, and you signed it with the formality of the will, and it was kept with your will typically. Nowadays, wills are mostly word processed, and so we just go back into the document, make the changes, and then re-sign it very simply. So I don't recommend codicils, and many lawyers don't do codicils anymore because they often get lost. So if you do have a codicil, make sure again that your executor knows that you have one. Okay, so now we're going to talk for a little bit about personal representatives. So It's a broad umbrella term, personal representative, that includes executors, administrators, and I'll talk about that in a little bit. But basically, we're going to talk about executors. So this is a skunk who says, it's from my executor of my grandfather's will. I've been cut off without a cent. So an personal representative is sort of the umbrella term that the legislature chose because your duties, as whether there's a will or not, your duties are actually very similar. If there is a will, it's called an executor. That's probably the term you've heard most often. If there's no will, it gets called an administrator. And when trusts are set up, the person gets called a trustee. So if you hear the term personal representative, it just means executor or administrator. You can appoint more than one executor in your will. That's a common question that I have in these seminars is, can I appoint my daughter and my son together to be my executor? The answer is you can. The more complicated answer is that we've worked with lots of daughters and sons who are harnessed together, and it actually can be really challenging on them because they both have to come to every meeting, they both have to sign off on every decision, and they have to sign all of the paperwork together. So personally, I'd rather just be the one doing it all and not doing it with a sibling or multiple siblings. And so you can name more than one executor, but chat with your kids and see whether there's one person who could do it. They'll get paid a little bit with an executor's fee, so they'll be compensated, but they have duties to all of the beneficiaries to make sure everything goes properly. And so it's not as though by having a child not be an executor, they don't have any say. You can also appoint a corporate trustee. So that's something that people often don't know about. There are lots of banks, for example, Bank of Nova Scotia or BMO, where they will take on the executorship of your estate. And that's often helpful if you have a big estate. If you feel as though your estate is going to have a big fight in it, which I know we all hope isn't going to happen, but sometimes it will. Or if you feel if you don't have any beneficiaries who are local or they're just American, then it may be wise to have a bank act as your trustee. If you're interested in that, you can just speak to whomever you typically bank with and they'll put you through to the trust department. So what are the things that a personal representative has to do? And this is regardless of whether there's a will or no will. They need to make funeral arrangements. Of course, we all know that that's something an executor always has to do. They need to identify what are the assets of the estates, what are the debts of the estates, and move things into the name of the estate, which can be a big job. They have to ensure that all assets are located. So often older people can secret away assets. And this goes back to what I said earlier, having the deceased write up a list of assets to provide to you before they die is the easiest way to have a comprehensive list. They also are responsible for the control and maintenance of assets. So if you have a business or a property, they need to make sure the property is insured, the lawn is cut, the lawn is shoveled, insurance is on everything. So it can be a very big job. So make sure whoever you're going to name as an executor is on board. Once they've, done the funeral, they've ascertained the assets, they've made sure everything is secure. They've often transferred it into the name of the estate. They've sometimes gotten a grant of probate to do that. Then they need to distribute it out back into the world. And so they need to determine the distribution instructions in the will. So that would be the case of a will. They have to find out who you've given your estate to and then carry out those instructions. If there's no will, we'll talk about this in a bit, then there is legislation that tells you who the beneficiaries are and what shares they get. Executors need to account to beneficiaries. That means usually providing them with a full accounting of what's occurred in the estate. So you really want to make sure your executor keeps really good records. They have to deal with tax filings. There's a final return, which is sort of the end of somebody's life. They have to file a return. And then trust returns created when the estate comes into existence. And often an accountant will help with all of this, but you'll need a clearance certificate at the end of the day. That's, if you ever hear that term, it's a CRA document that basically says that the estate is up to date in its taxes and that you can distribute. They also need to deal with litigation if there's conflict between beneficiaries. So we all hope that our estate isn't litigated, but it's always possible that it might be. So that's something else an executor has to do. It's a very big job. So I'll talk briefly about dying without a will. People often ask us, well, I don't have a will, so what's going to happen to my estate? The answer is, oh, and here's another turkey. I don't know why there are so many turkeys in the cartoons, but it says, James did not leave a will, but he's still able to help determine which of you gets his inheritance, and he's got a wishbone. So the answer is, if somebody dies without a will, they've got what's called an intestate estate or an intestacy. That's an estate where there's no will. So if you ever hear those terms, intestacy or intestate estate, that's what it means. instead of an executor, which only occurs if you have a will, this is an administrator, and they administer and administrate the intestate estate. Often you need a grant of administration, which is very much like a grant of probate. And under the intestate succession provisions, which are in the Wills and Succession Act, it sort of creates a default will for those who pass away without a will. So what the legislature tried to do was to say, what would most people want with their estate? Now, one of the reasons why I encourage people to get a will is because the legislature doesn't always get it right. So if you have stepchildren, if you have a blended family, if you have minor kids where you need a guardian or where you need some trust, the legislature is not going to deal with any of that. They're obviously not going to give to charities. And so, although for some people this default will work, a lot of people it doesn't, and it can cause a lot of hard feelings. So if you go to the Wills and Succession Act, you can see all the different scenarios, but basically they contemplate every single scenario. If somebody dies with a spouse and they have no kids, it all goes to the spouse. If they have a spouse and the children are all of that relationship, it still goes all to the spouse. If you don't have a spouse, you don't have any children, you don't have any grandchildren, it goes up to your parents. If you have no spouse, no children, no grandchildren, no parents, then it goes to your siblings and so forth. So there's lots of different things. Everybody in the world will fit into one of these categories in terms of what you have when you pass away. But this is sort of the default provisions in the Act. So one of the last topics we'll touch on before we end the webinar is claims by spouses and dependents. So you've probably heard through the grapevine, through friends or family, that somebody's estate was really hung up on a claim that somebody brought, and that the will was challenged, or that somebody made a claim against the estate. One of the most common claims that we have against estates is what used to be called dependents relief. It's now been changed into maintenance and support. Little bit of a confusing title, because to me that sounds like a family law, you know, child support or spousal support, but it's not. Basically, the premise is that the legislature has mandated that when you die, you have to make adequate provisions for your spouse and for your dependents. So the Act, again, it's the Wills and Succession Act that sets this out, provides for spouses and dependent children. So that would include minors, so anybody under the age of 18, an adult disabled child who's unable to work by virtue of mental or physical disability, any child who's up to 22 years of age and in full-time post-secondary, or a grandchild if the grandparent is acting in the role of parent. So if you have a spouse or a dependent child that falls into any of these categories and you don't give enough of your estate to them for their maintenance and support, they can make a claim against the estate and alter the terms of the will. When I talk about spouse in this webinar, what I'm actually referring to is both a married spouse and what's called in Alberta an adult interdependent partner. For most people, they think of that as a common law spouse, but in estates and in other pieces of legislation, it's called adult interdependent partner, or AIP. In Alberta, to qualify for an adult interdependent partner, you need to be living together for 3 years or more, or if you have a child in that relationship, then just a relationship of some permanence. So it doesn't have to be 3 years, or if they've entered into an adult interdependent partner agreement. There used to be a provision to deal with matrimonial property and wills, but it was not proclaimed in force. But it's just good to know that if you have a spouse when you die, and again, that includes a common law spouse or an adult interdependent partner, they could make a claim against the estate. So to conclude, this is kind of your call to action. You've made it all the way to the end of Estate Planning Essentials. So obviously you're a very diligent and prepared person. Why not get all of these documents in place now? A lot of wills, a lot of powers of attorney, a lot of personal directives can go on for years. In fact, when we do them, we try to make them go on as long as possible. So even if it's a very young couple with no kids, we'll contemplate kids and grandchildren with the idea that hopefully you don't have to revisit these documents for a long time. It's a little bit of an investment on the front end, but I think as you've seen through this slideshow on the back end, if you don't do these documents, it can cause a lot of confusion and a lot of problems for your family. And so by creating that list that we discussed of all of your assets, finding out where they go, and getting a properly drafted will, power of attorney, and personal directive, you can ensure your family is prepared and leave the most organized estate possible for everybody. So this says questions are welcome, but since you're on a webinar, you can't ask me any. It has my line there and the general Reynolds Mirth line. You're welcome to call us. I'm actually one of a number of lawyers on our estate team. There's a lot of lawyers here who can help you. So that you know a little bit about Reynolds-Mirth, we do wills planning, will drafting, obviously powers of attorney and personal directives. We also do estate administration, so that's helping executors who've been named or beneficiaries who are in an estate to make sure estates flow out to the beneficiaries and get wound up. We also do adult guardianship and trusteeship applications. So if you don't have a EPA or PD, or you can't have one, then we can assist in getting those. And finally, we do estate litigation, which means if it has devolved into a big fight, we can also assist with that. So please use our firm as a resource. I hope this was a helpful webinar. And if you have any questions, please let us know. But thank you for joining me and for your attention.